Ladies and gentlemen, any of you have any difficulty following the instructions of the court not to discuss the case among yourselves or with anybody else during the recess? None of the jurors have answered affirmatively. So shortly you're going to begin your final duty, which is to decide the facts of this case from the evidence. Before you do, it's my responsibility to teach you all the law that applies to this case. The instructions are broken up into three parts, and I'll provide a recording of the entire instructions. The first part of the instructions will sound similar to those instructions I gave you quite a while ago now, those preliminary instructions. I'll just give you those instructions in much more detail. The second portion of the instructions will involve criminal responsibility, concepts of diminished capacity, the elements of the two indictments as it relates to aggravated rape, and one indictment for armed robbery. When I get to that portion of the instructions, I'm going to actually hand out instructions for you, so you'll have the recording, but you'll actually have them to read along as I instruct you. I think that'll make it easier for you to absorb the instructions. The third part of the instructions involve me selecting one of you as a foreperson of the jury, and then randomly reducing the jury to 12. Certain of you will become alternate jurors randomly, and I'll talk about that when we get to it. But the first matter I want to address is you and the way you've conducted yourself during this trial. And it has truly been extraordinary, the seriousness with which each of you has taken the awesome responsibility that you now have. The way you leaned into the evidence and listened to the evidence with the best that you could be. And everybody involved couldn't ask for more than the conscientiousness that you've brought to this responsibility that you now have. And I know you'll give me the same close attention as I teach you the law, and you'll continue to conduct yourself in jury deliberations according to the law as I instruct you. Which gets to the next point I wish to make, which is I will teach you the law that applies to the case. You must accept that law as I instruct you, whether you agree with that law or not. It's not for you to decide whether you think the law is wise or not wise, that it makes sense to you or doesn't make sense to you. You must accept the law as I instruct you, whether you agree with that law or not. Now, my responsibility during the trial has been to make sure that the trial proceeds in a fair, orderly, and efficient manner, to rule on issues of law, to rule on issues of evidence, and to teach you the law that applies to the case. It's my responsibility and my responsibility alone, should the Commonwealth prove one or more of the indictments beyond a reasonable doubt, to sentence the defendant. And you may not consider any sentencing consequences in your deliberations, since that has nothing to do with your role as the only judges of the facts of the case. I hope it's obvious to you throughout the trial that you should never consider, or any perception you might have about what I think you should do as far as deciding the facts of the case. Should you perceive I have a view of what your verdict should be, I'll tell you right now that I don't, and I'll tell you why in a moment. But to the extent you misperceive that I do, I instruct you to disregard it. When I'm listening to the witnesses on the witness stand, when I'm talking to the lawyers at the sidebar, it just never occurs to me to consider anything about the credibility of the witnesses. It would never occur to me to think of the evidence in those terms, the way the jury does. I'm busy doing my job to the best of my ability every day, and I just simply don't have a view of your verdict because I don't listen to the evidence in a way that would allow me to do so. I listen to every answer and review every exhibit as a judge of the law. Now, the attorneys, they have a grave responsibility during this trial. They have a very serious responsibility to zealously represent their respective clients. And sometimes they've asked to speak to me over here at the sidebar at the judge's bench, and more often it's been that you've been out of the courtroom for a period of time, sometimes for a long period of time while we were discussing issues of law. And members of the jury, that wasn't to keep important information away from you. It was so that I can make sure that the evidence was presented in a fair manner, and a manner that gave you a fair opportunity to evaluate its worth. You may remember I said at the beginning of the trial that if the sidebars went too long at any point in time, or you were out of the courtroom at any point in time, you are always welcome, and you still are, to be frustrated with me and hold it against me. Feel free. Just never hold it against the lawyers because they're performing their responsibility as advocates for their clients. Now, ladies and gentlemen, you might not have realized the full weight of what I'm going to say right now until this very moment. But you have the most important role in the trial. You have the most important responsibility in the trial. This case is not tried to me, it's tried to you. You are the sole and exclusive judges of the facts of this case. You alone determine what evidence to accept, how important the evidence is that you do accept, and what conclusions you should draw from the evidence. You must be completely fair and completely impartial. You may not be swayed by any biases or prejudices or personal likes or dislikes to either side, or because the charge is either popular or unpopular with the public. You can't decide the case based on emotion, based on sympathy. It's understandable to feel emotion for everybody involved in this case, but this case is not about emotion. It's about you carefully, assiduously, conscientiously reviewing the evidence, finding the facts from that evidence, and apply those facts to the law as I instruct you. You are not to decide this case based on anything you may have seen or heard outside of this courtroom, and you're not to engage in guesswork or engage in speculation. In short, you should confine your deliberations to the evidence, find the facts from that evidence, and apply those facts to the law as I teach you the law. Ladies and gentlemen, I want to talk a little bit about what is evidence in the case and what is not evidence in the case. These instructions are not evidence in the case. The closing arguments that you just heard, that's not evidence in the case. That was an opportunity for the lawyers to suggest to you what conclusions you should draw from the evidence. I remind you, as I have many times, it's your collective memory of the evidence and your collective memory of the evidence that controls. And those opening statements, those many days ago, were not evidence in the case. That was to give you an overview of what the lawyers expected the evidence would be so you could have a context as you listen to the evidence. Now, if at any point in time the lawyers reference the evidence or I reference the evidence, and your collective memory of the evidence is different, it is your collective memory of the evidence and your collective memory of the evidence alone that controls. It is your memory of the evidence alone that controls. Now, some of you took notes during the trial. Some of you took notes more than others. My suggestion was that you take notes sparingly. I certainly spent a lot of time during the trial, you probably noticed, going up and down the jury box, just making sure everything's okay, and I didn't see anybody who missed a trial with his or her nose in the notebook. But just keep in mind that the notes are not your memory, they're merely an aid to your memory, and don't use your notes to convince your fellow jurors of what the facts are. Now, What type of evidence do we have in the trial? Well, we have the testimony of the witnesses, their answers to questions. The Latin is viva voce evidence, the spoken word. Their spoken word to you is evidence in the case. Now, if a question was asked and I sustained an objection and you got no answer, questions are never evidence in the case. They're never evidence in the case. If I overruled an objection or rejected an objection, you have that answer before you. That's spoken word of witnesses to you. That's viva voce evidence, the spoken word. And when I overrule or reject an objection, I am not making any comment at all about what the weight or value of that evidence is. It would never occur to me to do so. I'm simply determining that it is an answer that you may consider along with every other answer in the case. Now, there's exhibits in the case, 140 of those exhibits indeed. And it's going to take a while after I finish my instructions to get all those exhibits with you in the jury room, but you'll have all those exhibits with you in the jury room when you deliberate in the case. The court took judicial notice of certain facts as true, and you have that evidence before you as well. When the court takes judicial notice, it's simply a shortcut to evidence, and you undoubtedly recall that evidence as it related to a couple of issues. There were also a number of stipulations or agreements between the parties. If it was agreement as to fact, you must accept it. If it was an agreement as to what testimony would be, you may accept it. Consider all the evidence as a whole, and keep an open mind. I'll talk about this more when you get in, right before I talk to the lawyers after the instructions. But keep an open mind. Consider all the evidence as a whole, and listen carefully and seriously to your fellow jurors, and share your own thoughts fully as well. Now, the indictments against Mr. Chism are only an accusation. They're not evidence. And the defendant has denied that he's guilty of the crimes charged in these indictments. The law presumes the defendant to be innocent of the charges against him. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves the defendant guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence since he is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless his guilt has been proven to you beyond a reasonable doubt. As I will mention numerous times when we go over the indictments, your verdict as to each indictment, whether it is guilty or not guilty, must be unanimous. All 12 sitting jurors must agree on your verdict. Or what is proof beyond a reasonable doubt? Well, the term is often used and probably pretty well understood, although it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed innocent until he is proved guilty, and the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Now, ladies and gentlemen, we have two types of evidence in a criminal trial. We have direct evidence and circumstantial evidence. You have a direct evidence when the witness from the witness stand testifies to you something that witness observed with his or her own senses, something the witness saw, tasted, heard, or smelled. In that situation, the only issue for you is whether or not you believe that particular witness's version of events. Now, you have circumstantial evidence when a witness can't testify to you directly about a fact to be proved, but you're presented with other evidence. And from that other evidence, you find facts, and then you draw reasonable inferences from them about the facts which have been proved to you. And the law allows either type of proof in a criminal trial. I'll give you an example of this. Let's say that you go home today, and when you get home, your next door neighbor says, well, I was over at your mailbox checking your mail for you like you asked me to. I went there at 10 o'clock. There was no mail in the mailbox. I went back at noon, and there was some mail in the mailbox. Well, you can draw an inference or a conclusion that sometime between 10 and noon, the letter carrier arrived and dropped mail in the mailbox. On the other hand, if your neighbor's looking out the window and says to you, well, I saw the letter carrier arrive at 11:28, you have direct evidence of what the letter carrier, when the letter carrier arrived. And the law allows either type of proof in a criminal trial. Two things to keep in mind about circumstantial evidence. The first one is this: you may only draw inferences and conclusions from facts that have been proven to you. And the second point is this: your inferences and conclusions, they need not be inevitable, but they need to be reasonable, they need to be consistent with each other, and together they must establish the defendant's guilt beyond a reasonable doubt. So all an inference really is a permissible deduction that you make from evidence that you have accepted as believable. And we do these things in our everyday life. They're just small steps in reasoning where you take some known information and apply your life experience and common sense in order to draw a conclusion. And I think I want to spend a few minutes talking to you about the role of the jury and your ability to utilize your common sense and your life experience. All of you came to jury duty and have now with you common sense and life experience. And really, that common sense and that life experience is the great contribution that you all have to make to our system of justice. And when you're examining the exhibits, when you're listening to the witnesses on the witness stand, when you're deciding the credibility, the believability of the witnesses, as the only judges of the facts of the case, you obviously want to bring to bear that common sense and that experience in life. Because it will be your duty, and your duty alone, to determine any disputed questions of fact. You will have to determine which witnesses to believe and how much weight or belief to give each witness's testimony. You should give each witness's testimony whatever degree of belief and importance you believe it is fairly entitled to receive. You have great power in this regard. You can believe everything a witness says, you can believe nothing a witness says, or anywhere in between. Ultimately, it's up to you to resolve any conflicts in the testimony and decide where the truth lies. If you do not believe a witness's testimony that something happened, of course your disbelief is not evidence that it did not happen. When you disbelieve a witness, it just means that you have to look elsewhere for credible evidence about that issue. Now, in deciding whether or not to believe a witness, or how much weight or value or importance to give a witness's testimony, again, you apply your own common sense and life experience. Often, it's not just what a witness says, but how a witness says it. It may give you some clue or some insight into whether or not to credit a witness's version of events. You can consider a witness's frankness or lack of frankness when testifying, whether the witness's memory seems to be accurate or not accurate. You can take into account how good an opportunity the witness had to observe the facts to which the witness is testifying, whether the witness's memory seems to you to be accurate or not accurate. You can consider the age, the intelligence of a witness testifying before you. And you can consider whether a witness has any interest in the outcome of a case. Now, the fact that a witness has an interest in the outcome of a case doesn't mean that witness isn't trying to tell you the truth as that witness believes it to be, but a witness's interest in the outcome of a case is a factor that you may consider along with all the other factors in determining the credibility of witnesses. Where there are inconsistencies or discrepancies in a witness's testimony, or between the testimony of different witnesses, that may or may not cause you to discredit such testimony. Innocent mistakes of memory do happen. Sometimes people forget things or remember things differently. In weighing such discrepancies, you should consider whether they involve important matters of fact or minor details, and whether the discrepancies result from innocent lapses of memory or intentional falsehood. When you evaluate the testimony that a witness gave here in court, you may consider whether the witness made an earlier statement that differs from or contradicts in any way his or her in-court testimony. An omission from an earlier statement is inconsistent with a later statement of fact when it would have been natural to include the fact in the initial statement. If you determine that an earlier statement is different from the way the witness testified in court, you may decide that the witness's credibility or believability is affected adversely, or you may decide that it is not affected adversely. Now, I'm going to give you an instruction concerning expert witnesses, and I'm going to actually read you the instruction because it's an instruction that we've received from our Supreme Judicial Court when there's expert witnesses. In any case where there's expert witnesses. There's one more point about witnesses to address, expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field. Generally, in cases that are tried in our courts, both civil and criminal, witnesses may testify only to facts that are within their own personal knowledge, things that they have seen, heard, smelled, felt, or tasted. However, in a variety of cases, issues arise that are beyond the experience of lay witnesses. And in those type of cases, we allow a person with specialized training or experience, called an expert witness, to testify. And to testify not only to facts, but also to opinions, and the reasons for his or her opinion on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in his or her field, does not put that witness on a higher level than any other witness. You are to treat so-called expert witnesses just like you would treat any other witness. In other words, as with any other witness, it is completely up to you to decide whether you accept the testimony of an expert witness, including the opinions that the witness gave. It is also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such a witness in whole or in part if you determine that the witness's opinion is not based on sufficient education, experience, or the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained to you before, keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts as you find those facts to be, then you may reject the testimony or the opinion of the expert in whole or in part. You must remember, ladies and gentlemen of the jury, that expert witnesses do not decide cases. Juries do. In the last analysis, an expert witness is like any other witness in the sense that you alone make a judgment about how much credibility and weight you give the expert's testimony and what conclusions you draw from that testimony. You notice that the defendant, Mr. Chism, did not testify at this trial. The defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove the defendant guilty. it is not up to the defendant to prove that he is innocent. Under our system of law, a defendant has a perfect right to say to the Commonwealth, you have the burden of proving your case against me beyond a reasonable doubt. I do not have to say a word. The fact that the defendant did not testify has nothing to do with the question of whether he is guilty or not guilty. You are not to draw any adverse inference against the defendant because he did not testify. You are not to consider it any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses, the exhibits, the stipulations, and judicial notice. Sometimes evidence such as photographs were presented to you as jurors, and you'll have those photographs and exhibits with you in the jury room, and they may elicit an emotional response. It is natural and understandable to feel sympathy and empathy when you hear about a person who has been injured in a serious way or suffered in some way. But as jurors, you have sworn to take an oath to follow the law. I instruct you that the law says you must separate any emotional reaction on your part from the informational value and weight of the evidence. You are not to be influenced in any way by the unpleasant nature of some photographs. You must find the facts in this case based solely on the evidence. Evidence that a person has suffered harm or has been injured, and photographs depicting the alleged victim's medical condition may be relevant to fact questions that you have to decide as to the nature and extent of Ms. Richards' injuries as it relates to the state of mind of the defendant. But you can't find facts or base your decision on sympathy, anger, passion, or prejudice, pity for or against either side. Rather, your verdict must be based solely on the evidence in this case and these instructions of law. Which brings me to another point I'd like to mention, which is sometimes evidence was admitted for a limited purpose. When I admit evidence for a limited purpose, you may only consider evidence for the purpose for which it's been admitted and for no other purpose. The other thing I want to mention to you is that if an answer was given and I struck the answer from the record, that answer that was struck from the record is not evidence in the case. Now, you've heard testimony about a statement the defendant allegedly made to the Topsfield police concerning the offenses which are charged in this case. Before you can consider such a statement made by the defendant, you are going to have to make a preliminary determination whether it can be considered as evidence or not. You may not consider any such statement in your deliberations unless from all the evidence in the case the Commonwealth has proved beyond a reasonable doubt that the defendant made the statement that he's alleged to have made and that he made it voluntarily, freely, and rationally. In your deliberations, you may not consider any statement that the defendant made about the offense unless the Commonwealth has proved beyond a reasonable doubt both that the defendant made the statement and that he made it voluntarily, freely, and rationally. If the Commonwealth has met that burden, then you may consider the defendant's statement to the Topsfield police and rely on it as much or as little as you think proper, along with all the other evidence. When determining whether or not any statement made by the defendant was voluntary, you may consider all the surrounding circumstances. You can take into account the nature of any conversation that the police officers had with the defendant and the duration of any questioning, if there was any. You may consider whether the statement was made and when it was made. You may consider the defendant's physical and mental condition, his intelligence, age, education, experience, and personality. Your decision does not turn on any one factor. You must consider the totality of the surrounding circumstances. Certain records were admitted in the case. We sometimes refer to them as business records. For instance, by way of example, the Chase records. Before you may even consider a document as evidence that would be a business record, you must be satisfied, more likely than not, that the document was made in good faith, that it was made in the regular course of business, it was the regular course of business to make such a record, that the document was made before the beginning of the proceedings, and that the document was made at a time of the act or event in question or within a reasonable time thereafter. Now, ladies and gentlemen, what we're going to do is pass out instructions to you, and you might find this is a good time to stretch while we pass those out to you. Caitlin, can you do me a favor, flip it and rewind? Okay, ladies and gentlemen, I'm now going to instruct you on criminal responsibility. To prove the defendant guilty of any crime, the Commonwealth must prove beyond a reasonable doubt that the defendant was criminally responsible at the time of the alleged crime, was committed. The burden is not on the defendant to prove a lack of criminal responsibility. Under the law, the Commonwealth bears the burden of proving beyond a reasonable doubt that the defendant committed the crimes with which he is charged, and also that the defendant is criminally responsible for his conduct. Criminal responsibility is a legal term. A person is not criminally responsible for his conduct if he has a mental disease or defect, and as a result of that mental disease or defect, lacks substantial capacity either to appreciate the criminality or wrongfulness of his conduct or to conform his conduct to the requirements of the law. The phrase mental disease or defect is a legal term, not a medical term. It need not fit into a formal diagnosis. The phrase mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. It is for you to determine, in light of all the evidence, whether the defendant had a mental disease or defect. If the Commonwealth has proved to you beyond a reasonable doubt that the defendant was not suffering from a mental disease or defect at the time of the killing, the Commonwealth has satisfied its burden of proving that the defendant was criminally responsible. If you have a reasonable doubt whether the defendant had a mental disease or defect at the time of the killing, then you must determine whether, as a result of a mental disease or defect, he lacks substantial capacity either to appreciate the criminality or wrongfulness of his conduct or to conform his conduct to the requirements of the law. To establish that the defendant had substantial capacity to conform his conduct to the requirements of the law, the Commonwealth must prove beyond a reasonable doubt that any mental disease or defect that may have existed did not deprive the defendant of his ability to behave as the law requires, that is, to obey the law. The word appreciate means to understand rather than merely to know. Criminality means legal significance of conduct. Wrongfulness means moral significance. The Commonwealth must prove that the defendant knew and understood that his conduct was illegal or that it was wrong. It is not enough for the Commonwealth to show that the defendant merely knew or was intellectually aware that his conduct was illegal or wrong. Rather, the Commonwealth must prove beyond a reasonable doubt that a mental disease or defect did not deprive the defendant of a meaningful understanding of the legal or moral significance of his conduct. The defendant must have been able to realize in some meaningful way that his conduct was illegal or wrong. In considering whether the Commonwealth has met its burden of proof, you may consider all the evidence that has been presented to you during this trial. You may consider the facts underlying the crime and evidence of the defendant's actions before and after the crime. You may consider the opinions of any experts who testified and give those opinions whatever weight you think they deserve. In a moment, I will instruct you on the elements of the offenses that the Commonwealth alleges the defendant committed. Remember, the Commonwealth must prove to you beyond a reasonable doubt that the defendant was criminally responsible at the time the crime was committed. That is, that the defendant did not lack criminal responsibility at that time. Therefore, it is the Commonwealth's burden to prove at least one of the following beyond a reasonable doubt. that at the time of the alleged crime, the defendant did not suffer from a mental disease or defect, or 2, that if the defendant did suffer from a mental disease or defect, he nonetheless retains substantial capacity to appreciate the wrongfulness or criminality of his conduct and to conform his conduct to the requirements of the law. As I have previously instructed, your decision should be based solely on the evidence and the law of this case without regard to the possible consequences of your verdict. You may not consider sentencing or punishment in reaching your verdicts. However, I'm going to tell you what happens to a defendant if he is found not guilty by reason of lack of criminal responsibility. First, the court may order the defendant to be hospitalized at a mental health facility for a period of observation and examination. During this observation period, or in any event within 60 days after the verdict of not guilty by reason of lack of criminal responsibility, the district attorney or other appropriate authorities may petition the court to commit the defendant to a mental health facility or Bridgewater State Hospital. If the Commonwealth concludes that the defendant is mentally ill and that his discharge would create a substantial likelihood of harm to himself or others, then the court will grant the petition and commit the defendant to a proper mental facility or Bridgewater State Hospital initially for a period of 6 months. At the end of 6 months and every year thereafter, the court reviews the order of commitment. If the defendant is still suffering from a mental disease or defect and is still dangerous, then the court will order the defendant to continue to be committed to the mental facility or the Bridgewater State Hospital. There is no limit to the number of such renewed orders or commitments as long as the defendant continues to be mentally ill and dangerous. If these conditions do continue, the defendant may remain committed for the duration of his life. If at some point the defendant is no longer mentally ill and dangerous, the court will order him discharged from the mental health facility or from Bridgewater State Hospital after a hearing. The district attorney must be notified of any hearing concerning whether the person may be released, and the district attorney, as I said, has a right to be heard. However, the final decision whether to recommit or release a defendant is always made by the court. This is what happens if you find the defendant not guilty by reason of lack of criminal responsibility. Whenever the defendant's knowledge or intent must be proved, the defendant's culpability rests upon proof of such knowledge or intent. The Commonwealth must prove the requisite knowledge or intent beyond a reasonable doubt in order to prove that the defendant committed the crimes charged. Whenever the Commonwealth must prove the defendant's intention to do something, you should consider any credible evidence of mental impairment in determining whether the Commonwealth has met its burden of proof. Likewise, whenever the Commonwealth must prove the defendant's knowledge of any facts or circumstances, you should consider any credible evidence of mental impairment in determining whether the Commonwealth has met its burden of proof. More particularly, you may consider any credible evidence of the defendant's mental impairment in determining whether the defendant deliberately premeditated the killing of the deceased, that is, whether the defendant thought before he acted, and whether the defendant reached the decision to kill after reflection, at least for a short period of time, whether the defendant intended to kill or caused grievous bodily harm to the deceased, or was aware that his conduct created a plain and strong likelihood that death would result, whether the defendant acted in a cruel or atrocious manner in causing the death of the deceased, and whether the defendant had the requisite knowledge and intent as it relates to the youthful offender indictments of aggravated rape and armed robbery. I reiterate, whenever the Commonwealth must prove that the defendant intended to do something or had some knowledge of certain facts or circumstances, in order to prove the crime, you may consider any credible evidence of mental impairment in determining whether the Commonwealth has met its burden of proving the defendant's intent or knowledge. Now I'm going to talk about the armed robbery indictment. In this case, the defendant, Philip Chism, is charged in a youthful offender indictment with the crime of armed robbery. Indictment 002 alleges that the defendant committed an armed robbery of Colleen Ritzer's underwear. In order to prove the defendant guilty of armed robbery, the Commonwealth must prove 4 elements beyond a reasonable doubt. First element, that the defendant was armed with a dangerous weapon. Second element, that the defendant applied actual force and violence to the body of the alleged victim for the purposes of obtaining the alleged victim's underwear. The third element, that the defendant took the underwear with the intent to steal it. And the fourth element, that the defendant took the underwear from the person or immediate control of the alleged victim. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant was armed with a dangerous weapon. The Commonwealth must prove that the defendant consciously and purposefully had a dangerous weapon in his possession. The defendant must be armed at a point directly related to the commission and completion of the robbery. To be armed with a dangerous weapon means that the defendant had a dangerous weapon on his person, that he knew he had it on his person, and that he intended to have it on his person. A dangerous weapon is any instrument that by the nature of its construction or manner of use is capable of causing grievous bodily injury or death, or could be perceived by a reasonable person as capable of such injury. An item that is normally used for innocent purposes can become a dangerous weapon if it is intentionally used in a dangerous or potentially dangerous fashion. Therefore, you must determine whether the defendant used it as a weapon with the same intent to use it in a dangerous or potentially dangerous fashion. So there's a words right after that I don't know how it got there, sentence, which you should cross out. The law of armed robbery does not require the Commonwealth to show that the instrument was actually used. It is sufficient if the Commonwealth proves beyond a reasonable doubt that the defendant was actually armed with a dangerous weapon. The second element the Commonwealth must prove beyond a reasonable doubt is that the defendant applied actual force and violence to the body of the alleged victim. When actual force is used, it must be applied to or exerted on the body of the alleged victim. The degree of force used by the defendant does not matter so long as it is sufficient for the defendant to obtain the alleged victim's underwear against her will. The alleged victim must be aware of the application of such force. However, an opportunity to resist or actual resistance is not necessary on the part of the alleged victim. Where the Commonwealth proves that the defendant has exerted actual force and violence, no fear needs to be instilled in the alleged victim. The third element the Commonwealth must prove beyond a reasonable doubt is that the defendant took the underwear with the intent to steal it. This means the Commonwealth must prove that the defendant consciously and purposely intended to take and carry away Ms. Ritzer's underwear against her will with the intent to deprive her of the underwear permanently. Thus, the word intent refers to a person's objective or purpose. The defendant must have engaged in a conscious act with determination of mind to do the act, to take the underwear, and must have intended the consequences of the act, and Ms. Ritzer be permanently deprived of the underwear. The intent to steal must coincide with the force or threats against Ms. Ritzer. Therefore, it is not robbery if a person sets out to commit an assault and then as an afterthought commits a theft. In the same way, if a person has committed a theft that is over and done with and then afterwards displays force or threats, that is not robbery unless the thief has a continuing intent to steal. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant took the property from the possession or control of the alleged victim. The alleged victim need not have actual physical possession of the property. It is sufficient if the property is within the alleged victim's area of control. Property is considered under the control of the alleged victim when it is within her reach, inspection, observation, or control, so long as she can readily obtain possession of it, if not overcome by violence. The value or amount of the property does not matter, and the Commonwealth is not required to prove the property's value as alleged in the indictment, as long as the Commonwealth proves it has some value. In deciding whether the defendant had the necessary intent to commit an armed robbery of Ms. Ritzer, you may consider any credible evidence that the defendant suffered from a mental impairment. The defendant may form the required intent and commit the act of armed robbery even if he suffered from a mental impairment, but you may consider such evidence in determining whether the Commonwealth has proved these elements. Therefore, after considering all the evidence, if you determine that the Commonwealth has proven beyond a reasonable doubt each of the four elements I have just defined, you would find the defendant guilty of armed robbery. However, if the Commonwealth has failed to prove beyond a reasonable doubt one or more of these elements, then you would consider the lesser included offense of larceny. Once again, if you find that the Commonwealth has failed to prove one or more of the elements of armed robbery beyond a reasonable doubt as to the underwear, then you would consider the lesser included offense of larceny. Larceny is the wrongful taking of the personal property of another with the intent to deprive such person of such property permanently. In order to prove the defendant guilty of larceny, the Commonwealth must prove three elements beyond a reasonable doubt. First, the defendant took and carried away the property unlawfully. Secondly, the property was owned by someone other than the defendant. And third, that the defendant did so with the intent to deprive the person of the property permanently. I will explain these elements for you. The element of taking and carrying away is accomplished if the defendant unlawfully physically transfers the property from the other person's control or possession to his own possession or control. It does not matter if the transfer involves only slight movement or it lasts a short time. The term property includes, but is not limited to, items of personal property. The Commonwealth must prove that a person other than the defendant owned the property. The third element the Commonwealth must prove is that the defendant intended to deprive the owner of the property permanently. This may be proved by direct evidence or by inferences from the surrounding circumstances. For example, if a person takes property of another and disposes it with utter indifference to whether the owner recovers its possession, you may infer an intent to deprive the owner of it permanently. In deciding whether the defendant had the necessary intent to commit a larceny from the alleged victim, you may consider any credible evidence that the defendant suffered from a mental impairment. A defendant may form the required intent and commit the act of larceny even if he suffered from mental impairment, but you may consider such evidence in determining whether the Commonwealth has proved these elements. Therefore, after considering all the evidence, if you determine that the Commonwealth has proved each of these three elements beyond a reasonable doubt, as I've defined these elements for you, your verdict, if you reach the lesser included offense of larceny, would be guilty. If, however, the Commonwealth has failed to prove one or more of these three elements beyond a reasonable doubt, you would find the defendant not guilty of larceny. The defendant, Philip Chism, is charged in a youthful offender indictment with having committed the crime of aggravated rape on Colleen Ritzer. Indictments 2014-109001 involves the allegation that the defendant put his penis in Ms. Ritz's vagina. Indictment 2013-1447001, that should say 002, ladies and gentlemen. 002 involves the allegation that the defendant inserted a tree branch into Ms. Ritz's vaginal opening in the woods outside Danvers High School. These are two separate indictments. You must therefore consider each indictment separately. Your verdict as to each aggravated indictment must be unanimous, whether it is guilty or not guilty. In order to prove the defendant guilty of aggravated rape, the Commonwealth must prove the following three elements beyond a reasonable doubt. First, that the defendant engaged in sexual intercourse, either natural or unnatural, with the alleged victim. Second, that the sexual intercourse was accomplished by compelling the alleged victim to submit by force or threat of bodily injury and against the alleged victim's will. And third, that the sexual intercourse resulted in or was committed with acts resulting in serious bodily injury or was committed during the commission of the crime of assault and battery with a dangerous weapon. The first element the Commonwealth must prove beyond a reasonable doubt is that the defendant engaged in natural or unnatural sexual intercourse with Ms. Ritzer. Natural intercourse is normal intercourse. That is, it consists of inserting the penis into the female sex organ. Unnatural sexual intercourse in the context of indictment 002 involves the allegation that the defendant inserted a tree branch into Ms. Ritz's vaginal opening. Either natural or unnatural sexual intercourse is complete upon penetration, no matter how slight of a person's genital opening. In addition to the vagina, the female genital opening includes interior parts known as the vulva and labia. Penetration into the vagina itself is not required. The second element the Commonwealth must prove beyond a reasonable doubt is that the natural or unnatural sexual intercourse was accomplished by force or threat of bodily injury and against the alleged victim's will. The force needed for rape may, depending on the circumstances, be constructive force, as physical force, violence, or threat of bodily harm. The Commonwealth must also prove beyond a reasonable doubt that the defendant performed the sexual intercourse against the alleged victim's will. The Commonwealth must prove that at the time of penetration, the alleged victim did not consent. In other words, that the intercourse was against her will. If a person submits because of fear, it is not consent. The person must be free to exercise her will without restraint. You may consider evidence of the alleged victim's state of mind at the time of the alleged incident on the issue of consent. The alleged victim is not required to use physical force to resist. However, you may consider evidence of any attempt to restrain or confine the alleged victim, of violence by the defendant, or struggle or outcry by the alleged victim on the issue of force and consent. However, lack of such evidence does not necessarily imply consent or the absence of force, because in certain circumstances, physical resistance may not be possible. You may consider all the circumstances and the entire sequence of events in determining whether the intercourse was without Ms. Ritz's consent and her ability to resist. In order to prove the second element as to each indictment, that is, for sexual intercourse against Ms. Ritz's will, you must find one of the following. One, that Ms. Ritzer was alive at the time of penetration, or in the alternative, if you cannot determine that Ms. Ritzer was alive at the precise moment of penetration, that the killing and the alleged aggravated rape were part of one continuous event. The crime of rape requires penetration of a live human being. In the circumstances of one continuous event, it does not matter whether the alleged victim's death preceded or followed the sexual attack. For the alleged rape to constitute one continuous event, you must find beyond a reasonable doubt that the death and the alleged rape occur very close in time, almost simultaneously, and that the alleged rape must be inextricably intertwined with the event or events that caused the alleged victim's death. The Commonwealth must prove beyond a reasonable doubt that the alleged rape and the cause of death were tied together by a unity of time, place, and circumstance. When I speak of one continuous event, you are to determine whether this requirement, as with all the elements of each indictment of aggravated rape, separately. You must be unanimous as to each indictment whether your verdict is guilty or not guilty. The third element the Commonwealth must prove beyond a reasonable doubt is that the sexual intercourse was committed with acts resulting in serious bodily injury or during the commission of the crime of assault and battery with a dangerous weapon. Let me define those terms. Serious bodily injury means bodily injury which results in permanent disfigurement, protracted loss or impairment of bodily function, or substantial risk of death. In order to prove that the defendant committed an assault and battery with a dangerous weapon, the Commonwealth must prove three things beyond a reasonable doubt. That the defendant touched the person of Ms. Ritzer, however slightly, without having any right or excuse to do so. That the defendant intended to touch Ms. Ritzer, and that he consciously and purposely intended the touching to occur, and that the touching was not negligent or merely accidental. And third, that the touching was done with a dangerous weapon. The alleged rape and the aggravating event, serious bodily injury or assault and battery by means of a dangerous weapon, need not occur at precisely the same time. However, they must occur during the same criminal episode and constitute one continuous course of conduct. In order for the crime of assault and battery with a dangerous weapon to satisfy this element, you must also find the Commonwealth has proven beyond a reasonable doubt that the acts of assault and battery with a dangerous weapon allegedly committed on Ms. Ritzer went beyond those to facilitate the alleged rape. That is, if you find that the acts of assault and battery with a dangerous weapon were incidental to the alleged rape itself, you would find the Commonwealth has not satisfied the alleged rape occurred by assault and battery by means of a dangerous weapon. In deciding whether the defendant had the necessary intent to commit aggravated rape upon the alleged victim, you may consider any credible evidence that the defendant suffered from a mental impairment. The defendant may form the required intent and commit the act of aggravated rape even if he suffered from a mental impairment, but you may consider such evidence in determining whether the Commonwealth has proved these elements. Therefore, after considering all the evidence, if you determine that the Commonwealth has proven beyond a reasonable doubt each of these three elements, as I've defined them for you, looking at each indictment separately, then you would find the defendant guilty of aggravated rape. If, however, the Commonwealth has failed to prove one or more of the three elements beyond a reasonable doubt, as to each indictment, looking at each indictment separately, you would find the defendant not guilty of aggravated rape. If you conclude that the Commonwealth has proven the defendant guilty of the offenses contained in the indictments involving aggravated rape and armed robbery, after consideration of all the evidence, there are three other questions you must answer. Has the Commonwealth proven beyond a reasonable doubt that at the time of the offenses were committed, that the defendant was between the ages of 14 and 18 years old? Has the Commonwealth proven beyond a reasonable doubt that the offenses were punishable by imprisonment in state prison if the defendant was an adult, i.e. a felony? And has the Commonwealth proven beyond a reasonable doubt that the offenses involve infliction of serious bodily injury in violation of the law? I have instructed you on the term serious bodily injury in my instruction on aggravated rape. You should use that definition here as it applies to both youthful offender indictments. I instruct you that aggravated rape and armed robbery are felonies. Now I'm going to instruct you on murder in the first degree. The defendant, Philip Chism, is charged in indictment 2013-01-446001 with the murder of Colleen Ritzer. Murder is the unlawful killing of a human being. There are two different degrees of murder: murder in the first degree and murder in the second degree. The Commonwealth alleges that the defendant committed murder in the first degree on two following theories: murder with deliberate premeditation and murder with extreme atrocity or cruelty. You ought to consider each of these theories and may find the defendant not guilty or guilty of one or two of these theories. Your verdict must be unanimous, whether it is not guilty or guilty of one or more theories of murder. To find the defendant guilty of any of these theories of murder, meaning in this context, murder with deliberate premeditation or murder with extreme atrocity or cruelty, you must be unanimous. That is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element of that theory beyond a reasonable doubt. You should check the appropriate block or blocks on the verdict slip that I will pass out to you as to each theory on which you agree unanimously. I will begin instructing you on the elements and the additional requirements of proof as to each of these two theories of murder in the first degree. I will then instruct you on murder in the second degree. Murder with deliberate premeditation. I will define the elements of murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Ms. Ritzer. Secondly, that the defendant intended to kill Ms. Ritzer. That is, that the defendant consciously and purposely intended to cause Ms. Ritzer's death. And third, that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of these required elements in more detail. First element is that the defendant caused the death of Ms. Ritzer. The defendant's act is the cause of Ms. Ritzer's death, where the act in natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Ms. Ritzer. That is, that the defendant consciously and purposely intended to cause Ms. Ritzer's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. The decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration of whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. In deciding whether the defendant intended to kill Ms. Ritzer and whether he formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment. The defendant may form the required intent and act with deliberate premeditation even if he suffered from a mental impairment, but you may consider such evidence in determining whether the Commonwealth has proved these elements. After considering all evidence in this case, you find the Commonwealth has proved beyond a reasonable doubt each of the three elements I have just defined, then you would find the defendant guilty of murder in the first degree with deliberate premeditation. If, however, after your consideration of all the evidence, you find the Commonwealth has not proved one or more of those elements, three elements beyond a reasonable doubt, you would find the defendant not guilty of murder in the first degree with deliberate premeditation. Now, a second theory of murder in the first degree is murder with extreme atrocity or cruelty. So I will now define the elements of that theory. You shall consider this theory of murder in the first degree regardless of whether or not you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove that the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused the death of Ms. Ritzer. Second, that the defendant either intended to kill Ms. Ritzer or intended to cause grievous bodily harm to Ms. Ritzer or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And the third element is that the killing was committed with extreme atrocity or cruelty. I will now discuss these elements in more detail. The first element is that the defendant caused the death of Ms. Ritzer. The defendant's act is the cause of Ms. Ritzer's death, where the act in natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Ms. Ritzer, or intended to cause grievous bodily harm to Ms. Ritzer, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, this second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, that the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any elements of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Ms. Ritzer. Grievous bodily harm means severe injury to the body. The third element is that the defendant intended to enact, which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused Ms. Ritzer's death. If you find he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the acts intended by the defendant created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act in which the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from a mental impairment. The defendant may form the requisite intent even if he suffered from a mental impairment, but you may consider such evidence in determining whether the Commonwealth has proved these elements. In deciding whether the defendant intended to kill, intended to cause, let me talk about the third element. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed cruelty inherent in the taking of human life. You must determine whether the method or mode of killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death and on the resulting effect on the alleged victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following factors. Whether the defendant was indifferent to or took pleasure in the suffering of the deceased. The conscious and degree of suffering of the deceased. The consciousness and degree of suffering of the deceased. 3, the extent of the injuries to the deceased. 3rd, the number of blows delivered. 5, the manner, degree, and severity of the force used. 6, the nature of the weapon, instrument, or method used. And 7, the disproportion between the means needed to cause death and those employed. The 7th factor refers to whether the means used were excessive and out of proportion to what would be needed to kill a person. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the factors I have just listed. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment, in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. After considering all the evidence in this case, if you find that the Commonwealth has proven beyond a reasonable doubt each of the 3 elements I have just defined, then you would find the defendant guilty of murder in the first degree with extreme atrocity or cruelty. If, however, after considering all the evidence, you find that the Commonwealth has not proved any one of those 3 elements beyond a reasonable doubt, you would find the defendant not guilty of murder in the first degree with extreme atrocity or cruelty. If you do not find the defendant guilty of murder in the first degree by deliberate premeditation or murder with extreme atrocity or cruelty, then you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the lesser included offense of murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. The defendant caused the death of Ms. Ritzer. Second, that the defendant intended to kill Ms. Ritzer or intended to cause her grievous bodily harm, or intended to do an act which in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The requirements of proof for murder in the second degree are the same as for murder in the first degree with extreme atrocity or cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment, in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed murder in the second degree. If after considering all the evidence in the case you find that the Commonwealth has proved beyond a reasonable doubt each of the 2 elements I have just defined, then you would find the defendant guilty of murder in the second degree. If, however, after consideration of all the evidence you find the Commonwealth has not proved any one of those 2 elements beyond a reasonable doubt, you would find the defendant not guilty of murder in the second degree. The evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense. You have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find the defendant not guilty. Now, at this point in time, I'm going to turn to the 3rd portion of the instructions. This is the shortest portion of the instructions, and after I finish them, I'm going to talk to the lawyers at the sidebar. The first thing I need to do is select a 4-person of the jury, and the juror in seat 7, Mr. Richardson, will be the 4-person of this jury. You get no more honor for that, sir, or no more pay for that. However, you act as the chairperson of the board. You help organize the discussion. You make sure that everybody participates in the jury deliberations. That means all 12 sitting jurors participate in this manner, not just listening with seriousness and intensity and respect to your fellow jurors' views of the evidence, but that each juror share his or her views of the evidence. The four-person view of the evidence is no more or less important than the other sitting jurors. However, there are certain responsibilities that go with that position. In addition to organizing the discussion, you would fill out the verdict slip. Once you've reached a unanimous verdict, I will go over the verdict slip with you in a few moments. At this point in time, I want to talk about alternate jurors because it's a long trial. We didn't know if it was going to go into Christmas week. We're required to select alternate jurors in a case, and some of you are going to be in the position of being alternate jurors. And that's difficult, to be an alternate juror. It's difficult in an obvious way, in that you've all worked so hard and been so serious about your jury duty, and to be chosen as an alternate juror is difficult after you've invested your heart and soul, your intellect, your time, and your effort into this case. But the second thing I want to point out about being an alternate juror is that your duty is not done if you're an alternate juror. It is not infrequent that alternate jurors become sitting jurors. It is not infrequent that alternate jurors become sitting jurors. So if you are an alternate juror, there are two instructions I give you. They're both very difficult. And the second one is just as important as the first. As an alternate juror, you can't discuss the case with anybody else. You can't do any independent investigation concerning this case. You have to continue to comport yourself at every moment as you would expect a judge of the facts to do so, because you may become a sitting juror in the case. The second requirement of being an alternate juror is also very difficult. 4 of you are going to be alternate jurors if my math is correct. Actually, 5 of you are going to be alternate jurors, and you're going to be spending a lot of time with each other if you're alternate jurors. And while you can certainly talk about whatever you want, tomorrow I expect you'll bring some reading in, but the one thing you can't talk about at all at any point in time is your view of the evidence. That is incredibly important. Alternate jurors become sitting jurors more often than you'd think. And the alternate juror has to go into the jury room pure as the driven snow, not having talked about the case with anybody else. So it's imperative, if you're an alternate juror, that you not discuss the case among yourselves with anybody else. Now, a few years ago, we moved from our decrepit courthouse down the road that was built in 1841 to this new building. And when we did, nothing came with us except for this box right here that we used to choose alternate jurors. I don't point that out as some sort of historical footnote or as an aside. I point it out to tell you that since that building was built in 1841, since we started having jury trials in this Commonwealth, there have been alternate jurors. And I know if you are chosen as an alternate juror, you'll recognize the importance of continuing to conduct yourself as you would expect people who may well become sitting jurors in the case. The alternate jurors are chosen randomly, and Ms. Draper at this point in time, taking the foreperson of the jury, who from this point in time will sit in seat 16, out, choose the alternate jurors, please.
Following jurors have been selected as alternates. Jurors in seat number 1, number 4, number 5, number 9, and number 13.
Jurors, could you come forward with your notebooks? Those jurors who were called. Let me see. If you would, please. If you have any questions for me, I'm not suggesting that you should, but if you have any questions for me, the questions would be reduced to writing, signed and dated, and the time put on the question by the foreperson of the jury. If you do have any questions for me, I'm not suggesting you should, but if you do have any questions for me, do not indicate to the court or anybody where you stand numerically or otherwise in your deliberations until you are ready to return a verdict in this case. It is critically important that all 12 of you participate in the jury deliberations. So if anybody has to step out for his or her personal comfort, it's imperative that the conversation stop. Now, nobody's going to let a word be spoken when if you have to step out for your personal comfort or because you have to address something unrelated to the case. But it is the foreperson's role and the jury's role as a whole to make sure that the deliberations include all 12 deliberating jurors. Along those lines, I have no comment to make at all about the pace of your deliberations. No comment to make now, no comment to make about the pace of your deliberations ever. But if you do not reach a verdict today and you're released until 9 o'clock tomorrow morning and all 12 of you are here, you may not discuss the case at all when you all arrive until I release you back to formal jury deliberations. When you get here in the morning, if you do not reach a verdict today, when you go home and you come back in the morning, all 12 of you are there. Do not discuss the case in any way until I have returned you to formal jury deliberations. We need all the jurors and alternate jurors here before I can do that. Now, when you get in that jury room and you start to talk about this case, when you're sitting around that table, you're going to be struck almost immediately by the seriousness, by the conscientiousness of your fellow jurors, by your collective intelligence, your collective wisdom, your collective memory, and your commitment to this case. So when you walk into that room and you start to talk about the case, listen with respect and intensity and seriousness to your fellow jurors and share your views and keep an open mind as you have those discussions. I need a few minutes to talk to the lawyers at the sidebar, and then I'll have a couple of more comments to make here. Let's just make sure that's on. Okay, I may need to speak to the lawyers again. If I do, it'll just be for a moment. So, Mr. Foreperson, again, you'll sit in seat 16 every time you come in from this point on. You'll have the verdict slip and fill out the verdict slip once you've reached a unanimous verdict as to all of the charges. Your verdict, whether it's guilty or not guilty, as to each indictment must be unanimous. All 12 sitting jurors must agree. So as it relates to murder in the first degree, your verdict would be either not guilty, guilty of the offenses charged by deliberate premeditation only, or deliberate premeditation and extreme atrocity, or guilty of the lesser included offense of murder in the second degree, or not guilty by reason of lack of criminal responsibility. the foreperson is going to be in seat 17. I'm having a little bit of a math challenge today, evidently. Okay, as to the aggravated rape, there's two separate indictments for aggravated rape. You have to look at both indictments separately, and you must be unanimous whether your verdict is guilty or not guilty. If it's not guilty, you check off not guilty, guilty, guilty of the offenses charged, or not guilty by reason of lack of criminal responsibility. If you find guilty as charged, then you'd go to Part B, and you'd only go to Part B again if you found the defendant guilty. And then, if so, you would have to determine whether or not the defendant was between the ages of 14 and 18 at the time, on October 22nd, 2013, and the parties have stipulated to that age. And then Part C, that you need to determine whether the offense charged involved infliction of serious bodily injury or threat of serious bodily harm by the juvenile defendant. So that's as to aggravated rape. Again, looking at each indictment separately, the allegation in the bathroom and the allegation in the woods. And as it relates to armed robbery, again, your verdict would have to be unanimous, whether it's not guilty, guilty of the offenses charged, or guilty of the lesser offense of larceny, or not guilty by reason of lack of criminal responsibility. Since this is a youthful offender indictment, you'd also have to agree beyond a reasonable doubt, as with the other youthful offender indictments for aggravated rape, whether the defendant was between 14 and 18 years old, and the parties have stipulated as such that he was. And then you would also have to unanimously determine whether the Commonwealth has proven or not, whether or not the offense charged involved infliction of serious bodily injury or threat of bodily harm. So those are the verdict slips that you'll be required to fill out. Ladies and gentlemen, in a moment you're going to be a deliberating jury. Does counsel need to see me at all before? No? Okay. In a moment, you're going to be a deliberating jury. You're going to get into that jury room, and I know when you get around that table, you'll bring to bear what I've been talking about every moment since you first came in to court. That you bring to this awesome responsibility that you have the best that's in you, the best that you can be. That you consider the evidence, find the facts from the evidence, apply those facts to law as I instruct you in order to return a verdict in this case. Mr. Draper, if the court officers could please be sworn.
Yes, Your Honor. Do you solemnly swear that you will keep this jury in some convenient place until they are agreed, and that you will not suffer any person to speak to them, nor speak to them yourself unless by order of the court, or to ask them if they have agreed? And when they have agreed, you will return them into court unless the court shall otherwise order, so help you God.
I do. Mr. Foreperson, ladies and gentlemen of the jury, you may retire to your deliberations.
All rise. Jurors, you'll be taking your notebooks with you. Jurors, if you'll just remain a moment. You may stand. Sir, if you'll lead out, watch your steps going out.
I think I'll come out. Court will come back out after counsel is content with the slips and the exhibits. Court will be in recess.
All right.